everyone, it's Liz Barletta of the Barletta team at Ligris, and I'm so excited to have these two amazing professionals with me today. We are chatting with Annalee and Ricky from Best of Boston Living from Century 21 North Shore. Thank you both for being here. I'm so excited to chat with you guys.
Thank you. Thank you. We're happy to be here.
My pleasure, my pleasure. Yes, we are so excited to be here with you on the call today. Looking forward to chatting about real estate.
Yes. So I hear you have a couple of questions about how sort of the closing process works, which I think is a great starting point for buyers and even sellers out there who are interested in potentially working with our team here. So shoot, what's your first question, Annalee?
Well, absolutely. I think I will start it, Annalee. I think that one of the first questions we have, especially for our community, Spanish and Latin American community, the first thing they're asking is like, who's going to protect me in this transaction, or when I need an attorney, or what the attorney is going to get involved on in the process of the purchase of the property. I think that's probably the first question that we have, very common, as a matter of fact.
Yeah. So from a buyer's perspective, that's a great way to start. So from a buyer's perspective, definitely the attorney, I think, is an integral part. In fact, our legislature requires when there's a closing to have an attorney be involved in the transaction, and not just their name there, but actually have an integral part in the transaction. Because a closing in Massachusetts is considered the practice of law. So we want to make sure that our clients are protected. We do say every once in a while, like a seller potentially not hire an attorney, but that's at a very great risk, in my opinion, obviously coming from an attorney's perspective. As you both know, in Massachusetts, we have a contract after the offer has been accepted where the offer is preliminary, terms, closing date, price, property, but the purchase and sale agreement is where a lot of the meat and potatoes comes into play in the contract. And if that's prepared by a seller's attorney and you're on the buying side and don't hire someone to review your P&S and be your advocate through the process, you're accepting all these terms that are favorable to the seller. Likewise, if you're not hiring a seller's attorney and you are a seller, a buyer's attorney is going to add a bunch of stuff into this purchase and sale agreement, and you don't have someone advocating for you to limit any kind of risk or exposure. So from my opinion, like both sides should have an attorney. They're the person besides the two of you, which are, also fiduciaries in a transaction, but having that person who's going to guide you on the legal side of things and walk you through the process.
So that brings us to that second question on what is it that a seller or buyer should be aware of in a purchase and sale agreement?
So great. Okay. So purchase and sale agreement, let's start with the buying side. So typically on a seller's purchase and sale agreement provisions, I can go so nitty gritty or I can kind of go general, but just to give an example, typically on the standard purchase and sale agreement, the provision related to the condition of the property when you close is pretty general. It says that the property is to be delivered, in the condition as it is at this time. That means the day you're signing that purchase and sale agreement. Well, you as a buyer, you didn't generally visit the property that day. If you inspected it, that could have happened several days before that purchase and sale agreement was signed. So if you leave that open-ended to say that the property is to be delivered as it was when you signed the purchase and sale agreement, well, a lot of that information we have from the inspection may not be what we're looking towards in terms of condition. Because the seller could argue, well, yeah, that hole in the wall happened after your inspection, but it was the same day as your purchase and sale agreement was signed, so we're not fixing it. So that's a provision that we usually amend as a buyer attorney to state the properties to be in the condition as it was on the day of your inspection as a buyer. Again, then we have a report. We can look to the report and say, well, living room, no hole. You have a hole now, you're fixing it, seller. Right. From the seller's perspective, though, if a buyer attorney generally is going to add in a lot of stuff, they're going to add in lots of provisions, and a lot of them expand your risk. So it's the seller's attorney's role to limit that risk. So instead of a buyer attorney saying that a seller is going to warrant or guarantee basically certain conditions or information about the property. As a seller attorney, I'm going to strike anything that says warrant, and I'm going to leave anything that says represents, because representing to the best of your knowledge is different than guaranteeing something exists. So a lot of it is small nuances that obviously we're trained to see and advocate for our clients for, but that's sort of a little bit of the nitty-gritty of what we're looking at on both sides of it.
Okay. And are there any clauses for, if we were to talk about a buyer right now, is there any specific clauses that a buyer should negotiate or to do to add for protection of their interest that you see in purchase and sale?
So the thing that I'm seeing today, more than in years past, is that sellers not being flexible to add in what sometimes I would consider pretty standard in the purchase and sale agreement, because it wasn't part of the offer. So more and more I'm saying, for example, condominiums usually have a provision that say in the offer that everything's subject to the buyer's review of the condominium documents, right? That's usually something that our agents will add in. I've had a situation, not with your clients, but with other agents who are unfortunately more novice and don't know, they didn't add that provision in, right? So what happens typically if you are negotiating and reviewing those condo docs, and maybe let's say this buyer has a pet that is like, part of their family, and they find out when I review the condo docs, there's no pets allowed. So in a situation like that, where this example where the novice agent didn't add in that language about the condo doc review period, well, the sellers have a justifiable concern to say, well, you don't have a right to terminate based off of the dog not being able to stay in the property because you didn't have that as a condition of your offer. In years past, it was kind of assumed. You have a buyer who's buying a condo, they have that right to check it out, whether or not that line was in there. But more and more, we're seeing a lot of sellers who have a lot more to choose from buyers, because the inventory is such that there's not as much inventory. So sellers feel empowered to say, well, no, I'm going to make it more difficult to sort of negotiate after. So if you want it, if it's part of what you're hoping for from your purchase, my best advice is making that super clear to your agent and getting it in the offer, because to get it into the PNS after the offer is accepted is becoming much more challenging.
So that kind of backtracks a little bit then, even, right, Ricky, so it would be fair to say that generally speaking, when a buyer is ready to make an offer, they really should hire a real estate attorney at the same time as you're presenting this contract.
Yeah.
Right? Because if you are not aware of all these problems and issues that can occur, then, you might put yourself in a bad spot in a situation. So the best time to hire an attorney should be the second you are ready to start making an offer.
Yeah,
I agree. And I mean, having you with us on our side, and it's always good because we can always, recommend the clients, a representation that will cover any of these issues, before we even move forward on an offer, But that being said, too, the other question regarding to that is that what happens if we say that the buyer decide to back out on the transaction, and you already have 2 deposits in, how they will be handled that, in your end, and try to protect the buyer.
So just to spin a little bit of what Annalie was saying, so typically, as most agents don't refer us in until after an offer has been accepted. But that's what I always tell my referral partners, like, don't hesitate to get me in first, not first, but like before you're out there shopping around, because one, I think it's best for the buyer, because then the buyer knows this is my loan officer, this is my real estate team, this is my real estate attorney. And that, because everyone who's bought a house knows, like, as soon as your offer gets accepted, it's like, organized chaos. I have to call for, up my loan application. Who's the inspector? Oh my gosh, I have to hire an attorney. What are you talking about? So it's so much that happens at once that I always feel it's like a better experience for the buyer to know, okay, this is my team. Now I just have to, do the inspection and, get my loan app going because I already know who my attorney is. I love that. And then to your point too, once things, if things are a little bit more challenging in the negotiation stage, because maybe there are multiple offers, so you have to be more competitive and how are we wording this or that? I love that opportunity to make sure that the language is how it should be, or to make sure that what they're trying to say actually makes it in sort of the legal language to protect them. Ricky, to what you're saying, offer accepted, P&S accepted, buyers put both deposits and they want to back out. Unless you have a condition in that purchase and sale agreement, you're free to back out, but it's at the risk of that deposit. So unfortunately, if you don't have a financing contingency, or if you do, but that's not the reason why you want to get out of it, it's because of some other reason, then unfortunately your deposit's at risk. I can't prevent that because that's sort of the whole point of a seller accepting an offer with a breakdown of deposits. So if there's something that is important to you, to be able to have sort of that backdoor way of getting out of a transaction, it needs to be discussed at the front end. Maybe it's because you're trying to refinance another property and use that as your down payment. Well, to be safe, you may want to add that as a condition. If it's that you want to make sure that your dog gets approved by the condo association, let's make sure that that's in there. So definitely having all of that conversation up front is I think key, and understand, and for the buyer too, because I've had situations where I think in my 12 years, I don't want to count, it's too many years, that I've been practicing law, that I've had, never really a situation except one where my client decided to walk away from their deposit. It just ended up, they had no justification. They were approved for their loan. They inspected the house and it was perfect. It just ended up not working out because they got a job offer somewhere else in the interim. And so, things happen, but that was their choice. They could have still bought it and then sold it. That's what I was saying. Buy it, then sell it,
Yeah.
You won't lose any money that way, but people have their, have their paths and their choices. So.
And how do you handle title searches, and what happens if there is a lien on the property, or how do you determine if there's a lien on the property?
So in Massachusetts, we have we actually go back 50 years in the history of the property. So a lot of people, even if they're buying new construction, they're like, why do we need a 50-year search? Well, land existed before that building. So something was there. Even if it was vacant, it still was owned by someone. So regardless of how new the structure may be, we still go back 50 years. So in that, we're looking at the registry of deeds. We hire a title examiner who lives at the registry, like that's their job, which to us, it's not something that we're doing in-house. We hire a professional who's there all day long. We think that just makes it better because obviously they live and breathe title. Once that title exam has been done by our examiner, then we actually have a title attorney that all she does is review title. So she is the expert. Then she's also in communication with all the title insurance companies that we work with to check on things like, is this a problem? Is that a problem? Are we good here? So that's sort of our back end process. But let's say we do find something. Well, we get a report from our office saying this file has a title issue. This is the issue. We reach out to the seller's attorney for them to resolve it. In the purchase and sale agreement, there is a provision that's standard in Massachusetts that says that the title, if there's an issue with the title, let's say, that the sellers have an automatic right to extend the closing up to 30 days. Kind of going back, the purchase and sale agreement that we negotiate, we always add a clause to that paragraph that says, but if the buyer's rate lock expires, then that's the timeline. So let's say the rate expires 15 days after closing, then that's all they've got. But let's say there is this title issue. Generally speaking, most issues can get resolved before closing. It's very rare, but it happens that you have a title issue that just cannot be resolved. And then at that point, if within that 30 days or less, depending on the rate lock, it's still not resolved, and that's a negotiation point for the parties to say, okay, are we going to extend further? But at that time, generally, like for the most part, what's happening, how long it's going to take. It could be that there's something that has to get resolved in court or whatever. And in that case, it's a little bit more tricky because in terms of figuring out timing. But yeah, we do that history research for our clients. It's part of it. We then, don't just accept what the title examiners say. We then have an attorney in our office who's looking through it every single page, make sure that that was done properly. So when you're buying it, we're going to make sure that you're buying that clear marketable title. Of course, we still recommend title insurance because title insurance will cover things that cannot be discovered. But that's a whole other conversation that maybe we can have another time.
Yeah, absolutely. So
Absolutely.
to make it short and sweet is a buyer will be comfortable knowing that they are going to have a clean title, a marketable title by the time they close. So that's something that your job
That's what's
is.
put in the purchase and sale agreement. That's what the seller's obligation is to deliver. If you
Yeah.
decide the buyer to accept insurable title, which again, we can talk about on another video one day, that's your choice to, along
Yeah.
with the lender, but the standard, what they are due to deliver. If they can't deliver it because there's an issue, then
Yeah.
that's again, part of what the purchase and sale agreement will discuss.
Perfect.
Awesome. Great.
Go ahead, Ricky.
No, I was just going to say it's a lot of information, and I hope that this video is going to be very helpful for our clients.
I love it.
Absolutely. I have one more question in here.
Sure.
So, and I know we've talked a lot about representations. Now, I do know that even though it all kind of makes sense to us that are in the business, to a lot of buyers and sellers, it does not.
Mhm.
So, tell us in your words, what is your actual role at the closing?
Yeah, so a couple of things. So I'll talk about the contract itself because that's one part, and then the closing too. So on the contract itself, like the purchase and sale agreement, you're getting this 20-page, sometimes less, sometimes more Word document or PDF once we convert it. It's a lot of words on a page. So one of the things that we do is we always encourage, in our introductory phone call, we always explain to a client, like, how you learn is different than how I learn and how another client learns. If you are the type of person who needs to jump on the phone with us, go literally section by section, we're doing it. If you're a person who doesn't like that, because there are people who they don't like to be on the phone and ask questions. They like to do it themselves and then ask the questions. So we are very, aware how everybody sort of learns differently. And we encourage that. Like from our perspective, we like to be teachers of what we're doing because it's one of the most important, events of your life. You kind of want to know what's going on. So from that perspective, we take that approach where it's focused on what the buyer or the seller feels they need. And then they tell us, yes, I want to walk through it on the phone section by section. I only want to hop on the phone once I've reviewed everything with specific questions. Cool. We do whatever the client needs. From the closing table too. So, we have our certain personality types of buyers that when we're walking through a document that they're signing at closing, it's literally word for word. We're talking through exactly what it is they're signing. Other clients, it depends on their, maybe they have a certain career type that they're very keen on understanding these types of documents. So they don't need as much explanation. And so we kind of, mirror and match our clients in a sense because we want them to have a good experience. And if you have a client who has a personality that doesn't like a lot of chatter, they're not going to be happy at us, like talking to them, word for word when they're like, we got it, we understand. So we try and really mirror and match our clients as, I think that just makes it for a better experience for them. And so that's sort of how the closing looks like. We really try and focus on what the buyer needs, but make sure that they understand the most important parts of their transaction at the closing table, and then some, depending on who it is. But the numbers, that is section by section. We're going through that closing disclosure to make sure they understand where the money's going. And also explaining that there's a lot of this stuff that they have already signed at the application stage that they're just kind of re-acknowledging at the closing table. But yeah, so it's dependent on the client. That's where we sort of focus.
Okay. And another question, as we were talking about closing. Now, we're going to talk about buyer. What documents can a buyer expect to review and be signing at the closing?
Yeah. Nowadays, some lenders do these hybrid closings where half of the file they're signing in advance and another portion they're signing at the closing table. But every lender is different. You could have a 150-page closing package, you could have a 30-page closing package. But the most important parts of what a closing package will look like, you have a closing disclosure, which is your figures. Unless it's cash, then we'll still use a settlement statement. If you're financing, you're signing your mortgage, you're signing a promissory note. So the mortgage is what becomes the lien on the property to enforce your promise to pay, which is the promissory note. You're going to be signing disclosures relative to, private information, related to your tax returns. You're going to, all that sort of stuff that was, for the most part of your application, you're going to be signing again at closing. But the most important is the closing disclosure, the mortgage, the promissory note. And then if you're a buyer, of course, as a buyer, a homestead, if it's going to be your primary residence.
And can you I guess we can do that on a different call to explain. Most people don't know what a homestead is.
We can do that. I know that. I think Ricky has to run soon.
Yes.
Yeah.
I was just going to say that. I mean, the conversation is great. It's very informative, but I do have to take off.
Yes.
We can continue in the next meeting. And
absolutely.
All right.
Thank you.
Thank you so much, though. Appreciate it, and I will talk to you.
Thanks, Ricky.
Thanks. Okay.
And just to put a kind of like a close on it, I think there's so many aspects to a closing that happen. But I think this is a great sort of summary of like the key parts of how we're involved, and then we can kind of listen to the viewers too. And maybe part of that will be a little on Instagram. I'll ask viewers what other questions you may have, and we can focus in that way too.
Correct. And I think that, I think what people need to understand, I think more importantly, is just the total overview about when to hire an attorney, the process along, using an attorney, and really what is your role, right? Yeah. And I think that that's what people are being misled about and misunderstanding is your role doesn't just come at the closing table. To sign the documents. Your role starts from the beginning till the end. Yeah. And I do believe that it's very important for people to understand that, hiring a real estate attorney is really, honestly, the top priority for many, many reasons, because brokers, realtors, we are not attorneys. Mm-hmm. We cannot write legal sentences. We cannot put anything in contracts that has anything to do legally.
Right. Yeah.
And I do believe that that's what's really important. And I'm looking forward to having so many more sessions and calls to educate the buyers and sellers, because I know they're going to have lots of questions when it comes to this. But thank you so much for taking your time today.
I'm so excited to have spoken with you guys. And
yes,
it's bestofbostonliving.com. Make sure you follow Annalie and Ricky, and we'll see you guys soon on another call.
Sounds wonderful.